Good afternoon and welcome to today's webinar discussing the report Safe and Just Michigan released today, Driving on a Suspended Livelihood, an analysis of Michigan's license restoration process. Over the last several years, Safe and Just Michigan has been doing advocacy related to expungement, that is, sealing old criminal records, as well as expungement fares. And during this time, we have consistently heard from people that it's hard to get back on their feet, even with a clean record, because they can't drive legally. So we started looking into driver's license restoration policy to try to understand that issue better, and that research led to today's report. So just to provide a bit of context, so why are driver's licenses so important to a person's livelihood in Michigan? The simple answer is that Michigan is the birthplace and home of the US auto industry. It has for close to a century built itself around the car and Michiganders' collective ability to drive. There are over 7 million licensed drivers in Michigan out of 10 million people. And driving is central to most people's daily lives. Most people drive to work, to the grocery store, to see family and friends. And because the ability to drive is so important to daily life in Michigan, the suspension or revocation of a person's driver's license can be a life-altering event that results in job loss or requires a person to drive illegally on a daily basis to get to work. And we know from experience that many people do choose to drive illegally. Suspended licenses are a major driver of involvement in the justice system in Michigan. Just as one example, the Michigan Task Force on Jails and Pretrial Incarceration found in 2020 that driving without a valid license was the third leading cause of admission to jail in Michigan. And more broadly, this is an issue that affects a lot of people. There are hundreds of thousands of people with suspended or revoked licenses in Michigan. And in just the first 4 months of the year, 42,000 roughly additional suspensions were issued, affecting over 35,000 people. And I think significantly, about 19,000 of these were for either failure to appear for a court hearing or failure to comply with the court judgment. So we're not talking about reckless driving, that sort of a thing. So that's the broad context. To discuss our new report, I'm happy to welcome a distinguished panel of experts. First, we have Kamau Sandiford, the Clean Slate Program Manager at Safe and Just Michigan and the primary author of today's report. Second, we have Craine, the Chief Legal Director for the Michigan Department of State, which of course administers the driver's license system and rules in Michigan. Finally, we have Rubina Mustafa, Senior Staff Attorney at the Detroit Justice Center, who, among other things, helps people who need legal assistance getting their driver's license back. So, Kamau, I want to start with you since you wrote the report. From a policy standpoint, why is the issue of driver's license restoration important in a state like Michigan? What impact does a license suspension or revocation have on someone? And what concerns does the report raise about the existing restoration process?
Yeah, so thanks, John. And I think you touched on some of the points that I'm about to touch on right now. The reality is that millions of people across the state rely on their car to conduct their daily affairs. Talking about from going to work, picking up kids from school, going to the grocery store, simple, basic things that perhaps we may take for granted. Millions of people rely on that. The reality is there isn't necessarily a robust transportation system that people can rely on. So they often have to then rely on a car, which obviously creates an issue when you have a license that's suspended. And that's kind of the impetus for this report. Someone's license being suspended obviously impacts their daily life, but it can also place them in legal jeopardy. So it can increase the likelihood of them being picked up or going to jail because they're driving on a suspended license. So there's this, and what you'll see in the report is there's this balance of, well, I need to do X, Y, and Z, but at the same time, I have this suspended license, and there's a fear that by going about my daily life, I may end up in jail as a result of that. And that's kind of where the report kind of lands on.
Thanks, Kamau. And sort of a similar question for both Khyla and Rubina. You guys helped create the Road to Restoration clinics that have helped thousands of people get their driver's licenses back. Can you talk a little bit about why you started the clinics and what you've learned from doing them, and then the impact that they've had?
Sure. You want me to go? You want to go, Rubina?
You
Yeah,
go
you
first.
go first.
Okay. Well, first of all, thank you so much, John and Kamau, for having us here today, and glad to see all of you all are participating. So we created the Road to Restoration clinics in the fall of 2021. It launched officially in the spring of 2022, and it was to help residents understand their pathway to have their driver's licenses restored after the Clean Slate to Drive bills went into effect in October of 2021. So with those collection of bills, it eliminated a pathway for folks to be suspended based upon, speeding tickets or parking tickets or things that were just very low level, not really a major threat to public safety, and getting people caught up in this hamster wheel of fines, fees, and potential jail time. So we did our part of the Department of State to eliminate those from the driving records, and sent out a letter to residents informing them that they may be impacted by the Clean Slate to Drive laws. But we knew that that may not be enough. People may not read the letter. People may not even understand what their next steps were. And as a civil rights attorney, in actuality and at heart, I wanted to get on the ground with our residents to help them understand what they needed to do, what their next steps were. So working with Rubina and her wonderful team at the Detroit Justice Center, also our colleague Wendy Richards at Miller Canfield, and Mary Navraki at Lakeshore Legal, we started talking about what this could look like over the summer of 2021, even before the laws went into effect. And then working with our friends at DTE, who have been talking to us about the impact of residents that are coming out of prison who don't have a driver's license, and it inhibits them from being able to obtain the jobs that they earned while they were incarcerated. We all came together to put together this Road to Restoration Clinic. And over the past 4 years, it's been tremendously successful in talking to residents all across the state in both peninsulas about the various pathways on a one-to-one basis. And I'll pause there and let Rubina talk more about it.
So, and Khyla has been an amazing leader for all of us and has done just heroic work in pulling all of this together in all of the locations we've been at. But really, the vision was about bringing government to the people. It's definitely the first of its kind program in Michigan and in the country. We wanted to ensure that eligible residents knew if they could benefit from the change in laws. But one thing that I think a lot of people don't realize is driving records are private, and most people don't get a driving record update automatically. They don't even know what's on their driving record. So really, it was about really reaching out to the public and educating them, giving them their accurate and helpful information on how to restore or obtain their legal driving privileges. We have mobile branches of the Department of State at the clinic so that they can get their driving record, they can do any business, and definitely the guidance from the Department of State staff that is there to actually show them what's on their driving record, as well as the opportunity to consult with pro bono attorneys, gives them those instructions and next steps. So really, that was with this vision has come to life, and it really is something that gives people that critical guidance of what is going on with their driver's license. As you said, John, so many people who are justice impacted also have problems restoring their license, but the confusion, and I know we'll go into some detail about that, does depend on that individual circumstance. So having those, everybody gets a one-on-one consultation that comes to the clinics, and we're proud to say we've helped almost 10,000 people at the clinics.
That's awesome. That is so cool. And it's so necessary, honestly, because these are technical, very legal issues that I think a person off the street will struggle to navigate. And This is something we've seen in the expungement context too. It's just having someone who understands the law and understands the system to advise a person matters an awful lot in actually restoring their rights. So that's awesome. And I'm also really glad to hear it's a first of its kind thing, because that's another feather in our cap here in Michigan. In case anyone sort of like listening hasn't heard of this program, it has gotten some good media coverage over the years, but where's a good place to get more information about upcoming road to restoration clinics?
You can go onto our website, michigan.gov/R, the number 2 and R. And we're happy to drop that into the chat. And it'll have all of the next clinics. You can sign up for a clinic. And if there are any attorneys or paralegals in the audience as well, you can sign up to volunteer at the clinic as well, all on that same site.
Awesome. Thank you. So Kamau, as we've been discussing, this is like a pretty technical area. Could you give a brief overview of the reasons a person might get their driver's license suspended or revoked? And then maybe sort of highlight a couple of the most common.
Yeah, certainly. I think, when the public associates a license suspension, they often associate it with a DUI offense. And that is one of the reasons, yes. And then individual may have been convicted of a DUI, which would lead to a suspension, or multiple DUIs within a given period of time may lead to a revocation of that license. But actually, the most common reasons, and Rubina and Khyla can attest to this, tends to be from a failure to pay outstanding fines. And you'll be surprised how individuals can often accumulate multiple tickets from driving offenses over multiple jurisdictions, and that kind of leads to an accumulation of fees that they can't then get out from under, and then that leads to their license being suspended. So those tend to be the two most common reasons that we see in terms of license being suspended or revoked.
Thanks, Kamau. Khyla or Rubina, anything to add?
Sure. And yes, Kamau is absolutely right. Those are the most common reasons licensing privileges can be denied or suspended or revoked. The other thing, and this can be, they're not as common, but there are felony convictions that don't involve substance use convictions that do lead to a revocation of a license or suspension or some type of sanction. There's also, if somebody accumulates 12 or more points within 2 years, they can also face suspensions up to revocation. So there are kind of less common reasons. There are also individuals who, if they don't have insurance and they become financially responsible for an accident because they're sued by an insurance company, that can lead to a sanction. There's also child support sanctions. There may be out-of-state actions that do impose holds on their, ability to get a license in Michigan. And lastly, there are child support suspensions, which I know that the paper does address for people. It is one of the sanctions for child support. One of the reform laws that passed in 2021 or became effective in 2021 is suspending a driver's license for non-payment of child support is a sanction that can be imposed, but it can't be done automatically. They have to find other it's more of a progressive sanction. It has to be kind of the last resort that's what's done to enforce child support, but that is something that does occur. So, and that is why it's so complicated. Kamau's absolutely right. Those are the two most common sanctions we see, failure to pay and revocations for drunk driving. But it does, people should be aware that there is multiple, ways that the state is obligated. These are mandatory sanctions, mandatory actions the state must take. So that's why it's really important for coming to the clinic for us to individually explain to those individuals really what their sanctions mean.
Yeah, thank you for flagging those, because it just illustrates something I wanted to highlight here, and that is how many of these sanctions have nothing to do with unsafe driving, right? DUIs are DUIs, and I would set those aside in a different category. But when we're talking about unpaid child support or tickets or other things, we are not talking about driver safety. And that is typically the justification for suspending driver's licenses. But what we've decided to do as a state, and this is common nationally, is to use driver's licenses as a policy tool to create incentives for other kinds of behavior, such as to pay your child support. And it's leverage the state has, but I think the question we sort of should be asking from a policy standpoint is, should the state use leverage in this way because of the consequences to individuals of the state taking their driver's license away? I personally think, this is me editorializing, obviously, but like I personally think that the state has been too eager to use this power against people and that it has not internalized the consequences of doing so. So, like that's part of what the report is about.
Exactly.
And I think Kamau for highlighting those things. So getting to the restoration process itself, Khyla, could you just give an overview of the procedures the Secretary of State has established to govern restoration? And I understand just at a high level that there's separate processes for DUI and non-DUI cases.
Yeah, that's right. So there's a broad umbrella, and for the reasons that you illuminated, John, that there are many different pathways. So for certain people, all they need to do is pay a fine, and we will receive a clearance from the district court that they needed to pay. And then they're able to come to our office, pay a reinstatement fee, and then either renew their license or sign up for a brand new license as if their credential had expired 4 or more years since, right? So that's kind of the easiest pathway. There are other folks that Rubina highlighted that maybe had 12 or more points, or they were a fairly new driver. They got their license maybe 3 years ago and accumulated points very quickly. We require them to come see our members of the driver assessment team to talk to them, saying, hey, what's going on? You've accumulated a lot of points recently. You're a new driver. We want to make sure that you understand the rules of the road and that you can't drive on you can't drive like you're on the highway when you're just going down Main Street here in Ann Arbor, right? So you got to slow down a bit. And so we put a suspension on their driving privileges until they come and see us at the driver assessment. We talk to them. If we feel like they're going to be able to get back on the road safely, we'll lift that suspension and then continue to monitor them to ensure that they do understand how to properly drive on the roads. The next level is more complicated, right? That you have the hearings process for either the felonies or for people who have drunk driving issues, that they have to apply to have a hearing with our office. And so we have a packet that they have to complete, which is located on our website, but it's also provided to residents when they come see us at our clinics. And if they do come to our clinics, we will walk you through that packet, how to complete it, the time frames that are required for you to submit information, because that's not specifically listed on the packet. So if you're not aware of that, those can be little things that delay the process, because we'll kick it back to you and say, hey, your letters are too stale. You need to send us fresh letters, or your drug screen is too stale. We need an updated drug screen. So instead of getting complicated with those little nuances, we go over that packet at the clinic to make sure that folks are aware of that process. And then once people submit their information, we schedule them for a hearing. And then they have to talk to the hearing officer to help the hearing officer understand, have they abstained from alcohol? Have they abstained from substances? And that they can be safe on the road. And if that is successful, then they go to the next step of having a restricted license and using the interlock device in their vehicle. So it's multifaceted. It's a short way to say it, John, depending upon the person's individual issues. But I think that what we are trying to highlight today and what we talk about at the clinics is that it can be complicated. So our office is working very hard to find ways to simplify the process, to make sure that residents understand what they need to do, not to make it quote unquote easy, because we need to make sure that residents are going to be safe on the road, but we don't need to make it so overly burdensome and complicated that people will drive impermissibly on the roads that could also cause public safety issues as well. So it is the balance to make sure that residents understand what they need to do.
Absolutely. Kamau, Rubina, anything to add?
I would like to. I think Khyla did a great overview of sort of the different processes, but I kind of want to put it in kind of three major buckets, although there are many nuances. But the sort of the younger driver or the newer driver, she mentioned about driver assessment. It's just administrative, and it's through the Secretary of State's office. A lot of people are intimidated. And so one of the hopes with the clinic, and definitely the public education that we can provide, and hopefully your paper will also do this, is to let them know that to engage in the process, to understand their rights. I kind of fault a lot of this, and this is my editorializing, my personal opinion. The defunding of state funds for public driver's education in 2004 has led to a lot of these problems where younger drivers or newer drivers have a lot of points. So really, I mean, in my opinion, driver's education being publicly funded would solve a lot of those problems. Secondly, the confusion of Kamau referenced this of, when you're failing to pay fines and fees and have a suspended license, that's multiple courts. And so knowing which court to go to, what process that court has, making sure that court, sends a clearance. We've had experiences, me and my practice, and even at the clinic, of people waiting years for those clearances to be sent from the court to the Secretary of State. Most courts are able to do it electronically, but some don't. And so, for people to understand that process can be very difficult. And then, as Khyla said, the hearing application process can be very difficult. We really pride ourselves at the clinics, and I'm very grateful that I work with the team, the Road to Restoration team, because they really do break it down for individuals at the clinics, and we do as the attorneys working with people. That abstinence period Khyla referred to, it's abstinence from all alcohol and controlled substances, and a lot of people don't realize that until they come to the clinic. So it's of value, but they also need to know that breathalyzer in their car, that's going to be an expense, and a lot of people are discouraged. So Khyla's correct. Like, one of our goals is, as we're learning through the individuals we meet, every person's story is building the case for making this more accessible, including obviously the paper you guys are releasing.
So I don't know when the best time to do this is, but like Khyla, you mentioned Clean Slate to Drive. This is, that was a law that I think we all worked on in different ways. It was part of the Jails Task Force in 2020. And that was really what brought the issue of suspended driver's licenses to my attention, because I learned from that task force that criminal justice debt was resulting in the suspension of 360,000 driver's licenses a year. And I was just blown away by that. So, the long and the short of that, maybe I'll ask you to summarize, Khyla, but what was Clean Slate to Drive, and sort of why is that a really important reform?
Yeah, Clean Slate to Drive was a huge change, I think, for how residents are interacting with this kind of process. And so in December of 2020, it's about 3 or 4 bills packaged together to Clean Slate to Drive. And so it reformed in large part the failure to comply with judgment, FCJ, and failure to appear in court, FAC, provisions of the Michigan Vehicle Code. And so it reduced the types of sanctions that could default into an FAC or FCJ. So normally, any kind of vehicle or moving violation would be subject to a failure to appear in court or failure to comply with judgment additional sanction, which means then your license would be suspended if you didn't pay the fine or go to court within a specific certain time, and then all of the court fees that kind of divulge from there. So it limited the universe. That's number one. It also did what Rubina said, that all arrears for child support would, prior to this Clean Slate to Drive law going into effect, all of them would have suspended your license. So as soon as the friend of the court um, was made aware of your arrears, your license could be suspended automatically. Now, the court has to go through a process to determine whether or not you are um, deliberately not paying your child support, or if there's something else going on that makes it unavailable for you to pay the child support, and then between the judge and the prosecutor make an assessment of whether or not they should suspend your license. So that's two. The third thing it did is it made the changes retroactive, except for the child support part, unfortunately. So if we changed, I'm sorry, let me back up. The third thing that they did is they changed some sanctions from misdemeanors to civil infractions, which is huge also, right? So that those violations would not even put you into the criminal justice context. They would simply be a fine, which helps out in so many different ways. So now four. What it did, it made it retroactive, which is tremendously helpful because not only did it remove the suspension, but it also removed the reinstatement fee that would be tied to it from our office. So you have to remember that if you get suspended, you have to pay the fine for the judgment that remains. And you also had to pay a $45 clearance fee. And then once that violation was cleared, then you had to pay an $125 reinstatement fee to our office, along with the $18 to renew your license or the $25 to get a brand new license. So as you can see, these fees keep stacking on top of each other. So making the law retroactive, it allowed to remove the $125 reinstatement fee from people's driving history so that they don't have to pay that anymore, and also removed the suspension as well. What it did not do, of course, is eliminate the underlying violation. So you still was speeding, right? So you were still going down the lodge at 100 miles an hour. That's a problem, right? So you still have to pay for that violation to the court. And for most courts, you also still have to pay, you may have still had to pay the $45 clearance fee, but those other fees you did not have to pay. So it really made it a lot more accessible for residents to acknowledge what they, had done. You did speed down the lodge at 100 miles an hour, but also give you a quicker pathway to get your license restored. For some folks who had multiple issues, they still had to clean up some other things before they're able to reinstate their license, but hopefully it cleared the brush a little bit and really helping us focus on those things that impact public safety instead of making everything applicable to a suspended license.
That's awesome. Rubina, Kamau, anything to add just on those reforms and what might left to be do?
Well, I would just touch on just piggyback on what Khyla mentioned, with respect to the fee structure. I know prior to attending to these fairs, to these restoration clinics, I wasn't necessarily aware of how layered these fees were. I kind of just assumed there was just one big fee that a person would pay, and then that would be it. And I think what Khyla touched on is pretty important in terms of highlighting how layered these fees are. And so, yes, so for example, in 2018, there was the removal of the driver responsibility fees. That was one layer of those fees that were removed. But then you still had the other fees that Khyla alluded to. So yeah, I think that's something that's important to highlight as well.
So yeah, I would agree. And then the retroactive removal of the sanctions or the suspensions based on the failure to appear or the failure to comply with the judgment was huge. I mean, it just removed so many, thousands and thousands of sanctions from people, and it was just a huge relief. The implementation has many actors, so the Secretary of State did their part, but the courts, are, and independent actors. And so some courts have been like, oh yeah, we'll take away the clearance fee. We'll, for anything that had a clearance fee, that doesn't need it anymore. Some courts were like, oh yeah, let's help you get your license. Other courts, one of the areas of advocacy that I'm still working on is that there are some courts that don't like the law, and they've kind of retaliated against the law by requiring a person still pay every single fine and fee, even though that case is not suspending their license, before they will send the clearance for the case that is suspending their license. There are still infractions, such as the civil infraction of no proof of insurance, that will still suspend a person's license if it goes into default. And anything related to intoxicated driving will still suspend a person's license for failing to appear in court. So some courts have a lot of cases for individuals, and we can, I know we're getting to that point later, but so one piece of advocacy that we're working on, hopefully can educate all of the courts that, if you make it easier for people to get the benefit of this law, they will have a job and they can pay your other cases. But also it was important to educate individuals that this, what they may be encountering, since they still have to deal with their court cases, because again, the confusion of people not knowing their driving record, not even always knowing the courts, because some individuals will get a ticket, be too afraid to go, and not even know which court to go to or how to contact the court. So that's another thing we assist with at the clinic.
I've heard all three of you highlight fees as a challenging aspect of this, and Rubina, I just wanted to ask you to sort of highlight this. So what role do fees and court debt play in the restoration process? And then is the inability to pay outstanding debt and reinstatement fees a permanent bar to restoration?
Yes, I mean, and this is my crown issue. I do see it as a huge burden on really your average working American. The state doesn't mandate the judges' considerability to pay when they impose the original fines and fees. A lot of courts have, like, each municipality can decide how much they're going to charge. They have a limit. Most misdemeanors have a limit of $500. Some courts charge the full $500. Some courts only charge $50 as the fine. But then there are mandatory state costs and things of that nature that go on top of it. But no judge is required to say, hey, are you on public benefits? Hey, do you work? Some judges will ask, but there's no mandatory requirement. And, and courts also have a lot of enforcement mechanisms for collecting fees. They can issue warrants, they can do wage garnishment, they can seize tax refunds. And so it becomes like this huge money grab on top of, like we were talking about, clearance fees and so on and so forth. So, like, for example, we had a client who owed $4,000, and this particular court was one of the courts that said, you have to pay the $4,000 or we're not going to reinstate your license. My lovely colleague, Sharice McCauley, was able to get them to lower it to $2,000. But still, she's also argued that, hey, judge, just help her get her license back, then it'll be easier for her to get even the $2,000. But they, because so much of these calls are discretionary, the judge has the right to say yes or no. Although I think they're wrong. But anyway, I just feel very strongly that the state of Michigan should have a mandate that all judges must consider ability to pay before imposing the fine and fee, because and waive more of these, instead of having mandatory costs, there should be more waivable costs and fees, and judges should consider waiving the fees unless there was some reason to impose it. But having, it has become this sort of money grab, and that's the way I look at it. Is it's this money grab, and that seems to be the primary goal of these cases, rather than actually addressing the behavior. If the issue, as Khyla said, was speeding down the lodge, then okay, impose something that is proportional to that person, that's doable for them, instead of creating the cycle of debt and possible incarceration, because they're using the fear of incarceration as a way of enforcing those fines and fees. But I know we're going to talk a little bit more about this, so I'll stop there.
Yeah, well, I think it's important to highlight because again, it's a situation where we should be asking policymakers to justify the ways in which they're weaponizing fines and fees, and whether they're taking into account the people. Do you want this person to work or not? Do you want this person to pay back their fines and fees or not? Sorry, Khyla, go ahead.
No, it's okay. I agree. With Rubina. What I just wanted to add a little bit more context too is that when we came into office, there was a ongoing litigation, and a part of the settlement is that that on all your citations now, it does say that if you do have hardship um, paying the fine or fee, that you need to contact the court. And so they do need to consider your ability to pay when assessing judgment. Now, there's no mandate that they have to provide you the community service or anything like that, but there is supposed to be some consideration. Um, and so that is a part of, if you see, if you get a speeding ticket or something like that, on the back of it is cited that they do need to consider that going forward. So we're inching closer to where we need to be. Also, we worked with our colleagues over at the Supreme Court Administrator's Office, trying not to use acronyms. It's also called SCAO, to help courts understand that that is not how the secretary sees compliance with the motor vehicle code, that you had to pay all of your fines and fees in order to send the clearance, that you need to pay the fine or fee associated with the suspension. And once that is paid, you need to send the clearance to our office. So we were able to work with our colleagues over there at at the State Court Administrative Office late last year to send that communication to all district courts. And so we are continuing to work on things to improve the system. It's like turning a ship in the middle of the ocean. It doesn't turn fast, but it's turning. So hopefully attorneys and other clients will see the changes that we've tried to implement very soon, if they're not already seeing them.
That's great. And I actually wasn't aware of the communication with the courts there, but I actually do think that's a big part of the issue, is judges just not being up to speed sort of on ability to pay considerations just in general. There's a whole jurisprudence around excessive fines clause, both at the state and federal level, and people actually do have constitutional protections against the imposition of excessive fines, and those are not being, I think, incorporated into our day-to-day practice in Michigan courts in the way they should be. But that perhaps is for another webinar. But Rubina and I have talked about maybe the court rules could perhaps do more to incorporate ability to pay hearings or questions. So perhaps we'll be doing a webinar about that in the future. So Kamau, I think we're almost to the policy recommendations, and I probably need to move it along a little bit. But I just wanted to give Rubina the chance briefly to talk about, Detroit has been the inspiration for a lot of the policy work around driver's license access, and I just wanted to give Rubina the opportunity to talk about sort of why.
Sure, thanks. Well, I mean, just some basic facts. Detroit is the largest city in Michigan, but also the largest number of sanctioned drivers are in Detroit or originate from the Detroit area. Detroit's 36th district court. Each district court has a number. So they have the largest traffic citation docket in the United States. And it is by percentage the blackest city in the country. And it also has the highest rate of poverty of any city in the country, at least per 2021 statistics. It has the lowest high school graduation rate in the country. And the public transportation in the city exists, but the most efficient and reliable routes are closer to the downtown area. And so the reliability of public transportation to suburbs is not as robust and not well funded at all. So for many individuals in a near Detroit, there's this no-win choice of having to drive for work, school, healthcare, their children, and they take the gamble every single day to drive not only in the city but to nearby suburbs. And there is a history of the suburbs targeting Detroit drivers for traffic citations. When we were in person before the pandemic, you would see any given day, mostly Detroiters in those traffic courtrooms. Even though most cases are on Zoom now, it's just I call it a literal game of whack-a-mole for people to try to get to all of the courts to address their cases. Typically in the suburbs of Dearborn, Livonia, Ferndale, Hazel Park, Warren, and East Point, just to name a few. These are border suburbs to Detroit, and there's also there's cities inside the city, Highland Park and Hamtramck, that also target drivers too. So it's just, and Kamau referenced this earlier, it's this continuing cycle of having to address those court citations. So it is an area where the need is incredible. And we see it even at the Clean Slate fairs for expungements, like the over use of these sanctions, both financial and carceral, for people in the city just impairs their ability, their upward mobility to have a job, keep stable housing, be able to raise their family. And so I'm very passionate about, making sure people understand their rights, and that we fight for their rights to have a fair opportunity to really do what they're all trying to do, which is just live a decent life. And as we've said, many of these traffic citations are for failing to stop at a stop sign or speeding. And I'm not saying those don't implicate safety, but again, we eliminated driver education in 2004. So there are other ways to improve driver safety that don't involve courts and incarceration. And I would like to see those alternatives implemented.
Thanks, Rubina. So Kamau, we're going to finally talk about the report. I know it's like a lot of intro, but I think it's all really important context. So could you talk briefly about the research you did for the report and then the findings and feedback from the field that you discussed in the report?
Yeah, certainly. So what I would say is, and I can't emphasize enough the importance of the license restoration clinics in terms of allowing us the opportunity to see firsthand some of the issues that Rubina and Khyla mentioned. One that stood out to me in particular was one individual who essentially was on their way to work, and during the course of that day, they picked up multiple citations while on their way to work because they were going through multiple jurisdictions. And I think that kind of highlights some of the issues that Rubina and Khyla touched on. And that's really some of the feedback that we received while at these clinics. One, the issue of essentially over-policing in certain areas, which leads to individuals being cited for traffic offenses. And then the other issue dealing specifically with hearing officers and how they may view a case. We would often interview people who had already been in front of the same hearing officer and they may have been denied already. And they were kind of frustrated by the process because they know that they have to go back in front of that same individual or entity to get their license back. So yeah, that's kind of the basis for the report, and it really led to some of the recommendations that we see in the report as well.
Cool. So let's get to those recommendations. There's four sort of major recommendations. The first is to require an ability to pay assessment in court. Can you explain what that is and why it should be required?
Yeah, and I think Rubina, Rubina already touched on this a lot, but essentially, as the name suggests, the court has to make a determination as to whether the person can in fact pay the outstanding judgment without what it calls manifest hardship, and that the person has made a good effort to pay the judgment. And there's already a court rule in place, and I think Khyla mentioned that it is or referenced on the back of traffic citations. But again, one of the frustrating aspects of this is that the rule isn't necessarily consistently applied when you get to the court level. So that's one of the recommendations.
Cool. Rubina or Khyla, anything to add on that? Cool. I think the second one is also like we've covered it somewhat, but the second one is to make the $45 clearance fee waivable. Why would you recommend making that change?
Well, so first of all, some people might think $45 isn't that much, but when you couple that with some of the other bills or just daily livelihood stuff that people will have to take care of, $45 can be a lot for a lot of people. Additionally, these can accumulate, and I think we touched on this earlier, where it's potentially $45 per citation that you're having to then pay. So even removal of that fee, kind of like with the driver responsibility fees, it's one less layer that person would have to deal with when trying to get their license back. So that's why, that's one of the recommendations again in the report.
Rubina, anything to add?
Yes, this is one of the banes of my existence, and everybody knows. But the 45 clearance fees serve no legitimate purpose. I mean, literally, I don't think there is a legitimate governmental purpose, if we're going to put it in constitutional terms, for that clearance fee, because that particular fee comes up for the prior the FAC, FCJ, the failure to comply sanctions, that when a court reports noncompliance to the Secretary of State, in order to remove the noncompliance, a person usually has to pay the fines and fees that they owe to the court. But in addition to those high fines and fees, they have to pay this additional $45 clearance fee. And I can go into the weeds, but I won't. So literally, you've just paid the court all the fines and fees, that $600 for that $600 you owe them. And then on top of it, as Kamau said, for each infraction, it's $45. So, it's like, for a lot of people, there's 3 infractions. So that's $135, on top of the $600 they already paid, for the purpose of the court to just send a communication to the Secretary of State, whether that's a single piece of paper or an electronic communication. So I don't see any legitimate purpose for this $45 fee, because it's just a simple ministerial act. Also, now there are a lot of courts that still have that $45 fee for cases that no longer are, as the law's retroactive. So the failure to comply sanction doesn't exist anymore. And those the courts are still imposing this $45 fee for historical cases and even dismissed cases. That's what also can be very frustrating. We have people coming to the clinic who have when they run their Secretary of State driving record, it says they're suspended for not paying a case. When we look up that case or contact the court about the case, that case was dismissed and their license is suspended because they didn't pay $45. What is why is their license still suspended? And this happens a lot. I mean, I've seen it hundreds of times. And then if this person actually didn't have a dismissed case, they sometimes they'll hear in court, they'll hear, oh, you owe, $200 or whatever, but they don't know about the $45. And as Kamau said, they didn't know about it. So they come to court with their $200, but they're not going to get that clearance because they didn't come with that extra $45. So it's confusing. It doesn't serve a legitimate purpose. It's used for dismissed cases. It just has to go.
I think could not have been clearer. So I think those are really illuminating and helpful. The court process itself has a lot of barriers baked into it. The next two recommendations relate to restorations for DUI-related suspensions, and I feel that it's important for me to say at the outset that DUIs are a very serious public safety and public health issue. 40% of fatal traffic accidents are related to alcohol use. There are 30,000 DUIs annually in Michigan, and there easily could be more. We have a culture that does not, I think, stigmatize drinking and driving the way probably it should. And DUIs are the number one cause of admission to jail in Michigan. So this is just a huge, huge issue, and we think people should take it seriously. But I would say there are ways in which we do license restoration around DUIs that maybe are punitive in nature, or maybe make it too hard to get licenses back. So that's the general, I think, gist of the report. I don't want to be sort of give people the wrong impression, but the first recommendation relates to something that's known as the habitual offender rule. And so, Kamau, what is this rule and why should it be changed?
So essentially what it amounts to is there's a legal presumption under the law that a person who accumulates multiple DUI offenses within a period of time is considered a habitual offender, and therefore they have to overcome that burden. It's a clear and convincing standard that they're no longer they're able to drive safely, that type of thing. And so what I found, and I know Rubina and Khyla can attest to this, is that you often have individuals who come to these clinics who may have accumulated multiple DUIs back in the 90s, and they've not done anything since then, or they've not been convicted of a subsequent DUI offense, but yet they're still treated as a habitual offender. And so I think one of the more frustrating aspects of the law is that it doesn't account for necessarily the length of time that a person has gone without a subsequent conviction, or, in terms of that potentially being a mitigating factor, when determining whether or not that person should indeed have their license restored.
Okay. Rubina or Khyla, anything to add?
Rubina, you're on mute.
Go ahead, Khyla.
Okay. So DUIs, as John already laid out, is a really difficult and intertwined and complicated issue. So in one regard, as a person who used to attend all of the clinics and now in my new role don't get to attend as many, you do see, and it's heartbreaking when you see residents who are trying to get their licenses restored, who have been trying for decades to get it done and have not been successful. And at the same time, speaking with medical professionals who tell you that if a person has 2 or more DUIs, it could connote an alcohol related issue for them, and they really need to be in some kind of a program to deal with their alcoholism or substance abuse issues from a medical perspective before they're able to get the keys back or the privilege back to drive. And so we have to balance all of those out. And as the chief officer for DMVs here, the Secretary of State, is we have to make sure that all of persons who traverse our roads are doing so and safely. And as we have gone to places that have more DUIs than just fines and fees across the state, me as my own person, right? So taking out the hat that I wear with the Secretary's office, just a person that is there, it is concerning that there's so many DUIs in this locality or in this area, and I'm driving at night, right? I remember distinctly going up to an area and needing to come back home after a series of clinics and being petrified because I'm driving at night, it's pitch black. And knowing how many folks have had DUIs in that locale, you're petrified. I can't imagine what it's like to traverse that area day in and day out, knowing the numbers of folks that have struggled with DUIs in the past. And then overarchingly, not all the people who are, unfortunately, not all the people who are driving intoxicated are pulled over. So it's just the people who we've caught, not the people who have been drunk driving or driving while intoxicated on substances. And so it really is a very difficult terrain to traverse when we're talking about how do we do this in a way that ensures that the people who have the privilege to drive are doing so safely. We are not overly punitive for those persons who have been able to successfully deal with their alcoholism or deal with their substance abuse issues and should be granted access to get back on the road, as well as also dealing with the some ways where it's cost prohibitive for folks to be able to go through this process because they hired an attorney or they have to get the substance abuse evaluation and get all the other components, which can be costly, especially if you do it multiple times. So it's as with many things, it's not a simple solution. Along with the federal requirements that also come down that we have to adhere to as well. So it is a very complicated issue that we're dealing with, but our stance has been that we need to continue to look and refine this process so that we can make sure that Michiganders and folks that drive our roads are safe while also not being overly punitive, as you suggest at the outset, John.
Thanks, Khyla. Go ahead, Ben.
So I would totally agree with what Khyla is saying. I mean, it is a balance because we all have ourselves and our loved ones on the roads. We want them to be safe. I don't, and I remember, I'm old enough to remember when we didn't have fierce driving laws, and drunk driving, as you referenced, does cause a lot of injury, death, and harm and trauma. So, I mean, Michigan responded as many states have, which, creates this habitual offender sanction. And there was something that was signed into law in 2006 called Heidi's Law, which really was to address that if somebody did have this continual drunk driving behavior, that they could look at their entire driving history to appropriately charge them rather than just looking at the number of convictions within a span. But the sanctions, would be corresponding to their level of risk on the criminal side of things. So when we're looking at the revoked license, however, so what we need to separate out is, what is the appropriate portional consequence for somebody who's creating a danger? But then if our expectation after that is that the person achieves sobriety and abstinence and is going to prove they are no longer a risk, what does that process look like? And I look at it through two lenses, one as a lawyer, but also, as an advocate who says, well, some of these individuals had a substance use history for traumatic reasons? Did they get the healing that they deserved? And not one of the things, as Khyla mentioned, when you go up north, is not only there is a prevalence of these revocations due to substance use driving convictions, but there is a lack of resources for substance use treatment and healing. So how do we address this problem if we're not ready to invest in healing? And then secondly, for people to understand the administrative hearing and legal process, a lot of individuals, and one of the points of pride of our clinic is we are helping them, educate them about what the law is to restoration, because there just isn't enough attorneys. There aren't enough people for them to go to educate them on the process. So, we do see a lot of people who have had these drunk driving convictions in their younger years. They come to us in their 40s, 50s, and 60s, and they haven't drank in a while. Some of them have serious medical diagnoses that drinking alcohol or using controlled substances would exacerbate it. So it becomes this: how do you prove that you're not the same person in your 60s that you were in your 20s? And and I know Kamau's going to go into this in a little bit in terms of the recommendations, but it makes that burden of proof and putting everybody in the same bucket, having to show the same level of proof, very difficult. And so, we can't, we've reached a lot of people, but we can't reach everybody. So what improvements can we make to not only the healthcare of these individuals, but also the process that needs to be addressed to ensure not only, their healing, but also public safety?
And that's a great segue into the sort of fourth recommendation, and it relates to a hearing officer's authority under Rule 13. So Kamau, could you just explain briefly sort of what that recommendation is about?
Yeah, and so before we get into the recommendation, Rule 13 itself essentially is the subsection of the Michigan Admin Code that governs these types of license restoration hearings, and specifically deals with the criteria that the individual has to satisfy in order to get their license restored. The issue tends to be that the language used in Rule 13 is pretty broad in scope, and so it allows the hearing officer to consider a number of issues, which in some cases may or may not necessarily be indicative of whether that person is a threat to society in terms of continuing their substance abuse behavior. And I think that's part of the frustration that many have with that Rule 13, and specifically with the discretionary authority by the hearing officer. So one common theme that we would hear at these clinics is the hearing officer wanted me to show them that I was still doing AA, right? Even though the offense may have been 20 years ago, the person may have initially done some type of AA or some type of structured court-ordered rehabilitation program, and they may have successfully completed that. But then there's an ongoing expectation that that person continue to do that. And I think the frustration there is that just because I am no longer in that type of program doesn't necessarily mean that that my substance abuse problem is not under control. And so I know everyone touched on the balance that we're trying to strike here in terms of public safety, and then allowing people at least the opportunity to have their license restored. And I think that's part of the issue that we're seeing with respect to Rule 13 and Rubina. You can touch on that as well.
Yeah, go ahead, Rubina.
Well, I have sort of specific things, and I think Kamau did a very good job of explaining sort of that broad discretion and how it can be frustrating for individuals who have had a definite commitment to sobriety and abstinence. And so I do, I'm just going to echo again that balance. Hearing officers have a difficult job. They see thousands of applications. Many people are not represented or confused in the process. However, it's the bias problems that Kamau was referencing that I'm really sort of advocating to be reformed. Those, if you're not currently attending AA or a 12-step program, AA is not for everybody, and people have other methods of healing. So, there needs to be a recognition that if they have presented evidence that they have done other things to heal from the incident or what their circumstances were, and so the elements are not only your own story, but the substance use evaluation. So a licensed substance use evaluator provides an evaluation. If they're saying that this person is in recovery or in remission, and they have evidence that they are abstinent from using alcohol or controlled substances, then that should meet that burden of clear and convincing evidence. So the burden of proof is on the individual, but in the legal standard, a clear and convincing evidence standard is a very high burden of proof. Understandable, fine, but to eliminate certain lack of attendance at a 12-step program as not meeting your burden seems not fair and not really indicative of what true healing is. And then my other sort of a gripe is this reliance on unpublished decisions. And, our organizations do hear a lot from returning citizens, people who have been incarcerated and are trying to restore their driving privileges. And the hearing officers tend to rely on unpublished decisions. There's this case called Reynolds, which is not published, and I am saying doesn't have precedential value. And while it's a consideration that somebody was incarcerated, it is not a fact that the fact of their incarceration reduces their ability to prove their case that they were abstinent. So it's, because the Reynolds case talks about, you were in a controlled environment, and even people who are on probation, they consider they were on a controlled environment. I don't want to get into the weeds, and maybe we can do another webinar on that. But my concern is that bias of a person has to get out of prison and then not have a driver's license or not have access to a driver's license after getting out of prison for another year because they have to establish abstinence for a year doesn't seem fair. And it puts another barrier to somebody trying to legitimate their life and create a normal life for themselves. And so I was happy to see a decision in February called Delmont from the Court of Appeals that said it is an abuse of discretion for courts to rely on in these hearings, unpublished decisions, that they can consider them, but they aren't binding on that decision. So I'm going to be arguing that a lot. And also, I just feel like, you can appeal a hearing officer's decision to the circuit court where you live, and it should be a de novo hearing. Like, people shouldn't feel like they're pursuing these appeals and going through the legal process is this sort of waste of time. As Kamau referenced, there's so many individuals we've met at the clinics have gone through it and then just feel attacked or defeated. I should say defeated, not always attacked, but they feel defeated because they're like, I did this, I gave this letter, I did this, and I did this, and I was told no. And then, and there's really no way to dispute it because just simply procedurally, the person puts in their application for the hearing. They have the hearing on Zoom or Teams. It's a video hearing. Then they get the decision after a while, and they get this decision that they're arguing with this piece of paper, and then they have to go to the circuit court to try to dispute it. Now, some hearing officers are gracious enough to, if there was a missing piece of evidence, they'll give them time to issue a decision after getting a new piece of evidence, but not all hearing officers allow for reconsideration or allow for new pieces of evidence. So a lot of individuals, especially because most people do this on their own, they don't understand the legal procedure. They don't understand what is the next step. So I feel like individuals should have an accessible process, a more opportunity to consider their evidence, give them an opportunity to have some hope, because so many of them, I've seen people have had 2 or 3 negative decisions. Now, some of them deserved it, but some of them were just like, but you asked me for this time, I brought it, and then you didn't agree to it. So it's just a fundamental fairness issue of making the process accessible. But I could go into the weeds, but I won't.
No, that's great. And I don't know, Khyla, if you have anything you want to add. Um,
No, I don't. I don't think so. Given time, no. Thank you.
yeah, now we're over. So we're gonna bump Q&A. I don't think we've got a ton of questions anyway, but I would say, thanks so much to our expert panelists. I thought it was a really interesting conversation. I learned a lot, and I hope the audience did too. So with that, we'll say have a great weekend.
Thank you.
Thank you.
Good luck. Take care.